Yes, it has started.
Right. Yeah. So hi, folks. Hope all of you are doing great, and thanks for joining in. I'm Prabhas Sirivadana. Today, this is our 41st Silicon Valley IA meetup, and we have Paul. So Paul, I got to know Paul from his book on GDPR. It was written, I guess, published in 2017, very early days of GDPR. It's a very good informative read. And this second time, Paul presenting in our meetup, sometime back while he was visiting Bay Area. He's actually from Berlin. While he was visiting Bay Area, he did a talk at our meetup. And I think, yeah, so this is a very like exciting, interesting topic. Like, so everyone is talking about generative AI, the tools around that, and the impact those tools would have on privacy. So yeah, so welcome back, Paul, and over to you.
Yeah. Thanks very much, Prabhat. And as mentioned, please feel free to engage, to ask questions along the way, jump in if you have questions or if you disagree, and then let's just discuss the topic. And I will speak a bit about what's happening in the EU from a legislative perspective, and quite a lot is happening actually, but I will focus mostly on AI. And AI, of course, is like the hot topic at the moment. I was in Silicon Valley just a couple of weeks ago, and literally two clients separately told me that when ChatGPT came out, the CEO made a statement to the developers that they should stop all development work and just build in something with AI into their tools, regardless of what it is, because if a company can say their software is AI powered, then the multiples go up if you have another funding round. So AI is quite high on the agenda, but it's also quite high on the agenda from a political perspective and from a risk perspective. So a couple of weeks ago, there was a statement by stakeholders from the AI industry, and they basically said mitigating the risk of extinction from AI should be a global priority alongside other societal scale risks such as pandemics and nuclear war. So the industry itself compares AI and the risks coming out of AI with a nuclear war. And actually, even quite a lot of the developers or producers of AI software run around and tell everyone, oh, what we are offering to the market is actually really crazy shit, and we don't know the impact it's going to have. I mean, the founder of OpenAI basically does that. It's the product we're releasing to the market could potentially pose huge risks, but please feel free to use it anyhow. So quite a lot of discussion about AI and of course what good it can bring to the world, but also what existential risks exist deriving from AI. But there are not just existential risks such as extinction of mankind, but there are more tangible everyday risks that we have to deal with when developing, when deploying AI software. And there are some people saying, well, the fact that the developers of AI software claim there are so big risks is a bit to hide the smaller known actual risks and to steer public opinion away from that. So what kind of risks are we dealing with right now from a legal perspective? What do you have to do when developing or deploying AI? There are actually plenty of known risks. So one of the risks is, of course, liability. You use AI produces some results, and you rely on those results. And the question is, who is liable with what is happening? Yeah, who is liable, and to what extent can liability fall on you if you rely on respective AI tools? And it very often will. There's an interesting example of a lawyer, I think, in the United States that has had his writs to court written by ChatGPT. And ChatGPT, as you know, makes up quite a lot of things. Yeah, so if it doesn't know the answer, like, and you know that better than I, but the answers are made up due to statistical probabilities and not due to actual knowledge. So basically what ChatGPT was, they just cited court cases that didn't exist. And then the court told the lawyer, look, those court cases, they don't exist, please provide further evidence. And the lawyer went back to ChatGPT, and ChatGPT provided further evidence that was totally bollocks. So the respective lawyer was actually fined, I think, by the court in the US for having provided those results without having it checked. But there are other risks as well. And one very obvious one is privacy. Of course, if you use a tool, in particular, if you use a free tool that is available on the market in a B2C scenario, and you provide information on third parties, into your prompts, or the tools collect information, they gather it from the internet, scrape the internet in order to learn, and also collect personal information. The question is that permissible in the context of AI? Can you use it as a user to introduce personal data? Is the developer of the tool allowed to scrape the internet? So what kind of safeguards do you have to implement to ensure that while training these tools, while using these tools, that you don't actually commit some kind of privacy offense in that regard? Transparency is a big issue in that regard as well, because under applicable privacy laws, you often have to be very transparent about what kind of data you use and how you use it. But often you can't really tell how you use it because you don't know what the AI does with it. Yeah, does it remember the data you introduce? How does the AI work with it? Deletion rights are a huge problem. How do you get data out of the AI once it's in? So quite a lot of unsolved privacy issues in that regard. Another one, which is more an ethical concern, but which is also a privacy concern, is the reliance on the respective outcomes. So if you use software, for example, for making hiring decisions, there may be a bias in the software and you don't know it, you don't recognize it, and you rely on the respective decisions that the AI has come up with. And while this is an ethical question in the first place, at least under European privacy laws, this kind of profiling with effect to the individuals can be potentially considered as privacy non-compliance. Confidentiality is a huge issue, of course, already at the time being. You provide data to an AI cloud provider, and once you have prompted it to the AI, it may become part of the overall knowledge of the AI system. Yeah, there is this one example of developers working for Samsung that have uploaded Samsung proprietary code to ChatGPT to see whether there are errors within the code, and suddenly the proprietary software was within OpenAI's knowledge base, and you basically don't get it out there anymore. And the AI is trained on this proprietary source code that has been provided, and potentially with the right prompts, a third party can even get access to it. There are issues with respect to copyright. So to what extent is the AI permitted to train on data that is publicly available? Yeah, books, online information on websites. So this kind of information is very often protected by copyrights, and potentially you commit an infringement if you use such data to train the AI. But copyright can also be a problem with respect to the outcome of the AI. Yeah, you produce something, you think it is protected because you have produced it and you put it online, but it may not be protected because something that is entirely generated by an AI will potentially not be copyright protected. So quite a lot of issues to think about right now already, just based on ordinary laws that are applicable to AI. And you may want to think about, for example, implementing guidelines and safeguards within your company to protect you from potential exposure to those kind of risks. But That's not all, yeah. So this is like ordinary law applying to AI, but in a number of jurisdictions, and the European Union has been the first one to come up with a respective law. The legislator think the risks are so big, we should do more to regulate AI and to ensure that those risks don't materialize. So we have the AI Act, the upcoming AI Act in the European Union. And actually, we have similar laws popping up elsewhere. In China, for example, there are thoughts about a new law similarly regarding the risks deriving from AI. And by the way, in China, to protect socialist values as well. It's very important in the Chinese law that AI shall protect socialist values. But all these laws have some kind of a risk-based element in it, and they want to protect individuals from those kind of risks materializing. So what does the AI Act do? The AI Act basically wants to, or looks at various risks, and those risks are not necessarily extinction of society as a whole, but those risks rather relate to individuals. Yeah, the fundamental rights of individuals shall be protected, their health and their safety. And how does the AI Act do that? So basically, there are certain practices that are regarded as so harmful to individuals that they're prohibited overall. Yeah, and you're not allowed to do them at all. For example, you must not use AI that can be used to manipulate people so that they can be harmed psychologically, yeah, or to abuse vulnerable persons so they are harmed. Social scoring, the way we know it from China, cannot be used based on, or cannot be conducted based on AI if this leads to disadvantages to the individuals that are unreasonable. Predictive policing, for example, the way we know it from Minority Report, also strictly prohibited by the AI Act, which, by the way, probably will enter into force over the coming month. So it will apply in about 2 to 3 years, roughly, in the EU, but also in countries outside the EU, because the territorial scope of application of the AI Act is extremely broad and covers even developers or users to the extent that the risks or the results of the use of the AI materialize within the European Union. So very, very broad scope of territorial application. So as mentioned, there are some risks that are so relevant that they're entirely, or so use cases that are so risky that they're prohibited entirely. But there are also use cases that are regarded as very risky, as high risk, but which are not necessarily prohibited. For example, what we often see already right now, the use of employment and recruitment tools, yeah, where hire or fire decisions are made exclusively by the artificial intelligence, or access to essential services. Yeah, do you have the right to get access to healthcare, and a decision made by an AI? And those kind of very high risk use cases, they're not prohibited per se, but the legislator says the risk is so high, we really want to do everything to avoid that the actual risks materialize. And basically they say you can do it, but you can do it only under very extremely limited circumstances. Otherwise, it is prohibited. What are those requirements? So they're very much into depth and very, very burdensome. So burdensome, to be honest, that the requirements are almost prohibitive, actually, even though they should not be prohibitive, but just difficult for the developers and deployers of the AI tools. So what do you have to do? If you develop a respective tool, you have to implement adequate data governance mechanisms. So you have to ensure a very high quality of data sets, in particular regarding the data, the training data, which needs to be accurate and non-biased, which of course is super difficult to achieve. You have to implement very thorough cybersecurity protections into the AI tools, cybersecurity, and I will say something about that in a few minutes, is actually very, very high on the agenda of the European legislator as well. So we have quite a lot of new laws coming up and focusing exclusively on cybersecurity issues, and even various laws that don't exclusively focus on cybersecurity issues, but have a lot of cybersecurity requirements implemented as well. Transparency is a big issue. So you have to be transparent about the fact that you are dealing with artificial intelligence. Yeah? For example, when it comes to deep fakes, which are not necessarily high-risk AI systems, but still risky to some extent, you have to inform the person communicating or seeing those deep fakes. This is not the real thing. This is just a fake based on AI. But transparency can also mean that you give documentation to the user, explanation on how the AI systems work, how they should be used in practice, what kind of risks exist, and at what point in time I can no longer rely on the respective outcome of the AI, and when I need human oversight to actually control the AI, because not only the AI has a bias, but the humans that use it have a bias as well, which often goes into the direction that we think if we use technology and technology comes up with a calculated result, then we tend to assume that the result will be right, probably better than the result that we have taken because it has been calculated by a computer, which of course is not true. So we have to give information about how to use the AI and how to actually implement adequate human oversight to minimize the existing risks. You have to run through a conformity assessment with respect to the artificial intelligence and ensure that all the requirements, the very, very onerous requirements from the AI Act are actually fulfilled. And depending on the AI that you produce, this may even have to be assessed by an official third party who confirms that you're in compliance with the law. You have to build up logging, so protocols, so that everything can be traced back. And you have to ensure requirements or risk mitigation systems for the entire life cycle of the respective AI. So very, very, very burdensome obligations with respect to the deployment of the AI, or sorry, the development of the AI, and to a bit lower extent also for the users or companies selling the respective AI. If this enters into force, this will really impact companies using and developing or implementing AI into their systems. So much that there are, similar as we had it with the GDPR, there are actually talks ongoing in Europe. This is prohibitive. Basically, we are hurting ourselves because the requirements are so high here in Europe that we all run out of Europe and go to the US to actually produce AI systems because the requirements are so burdensome, we can't keep up with them. However, as I already mentioned, you probably can't escape the respective requirements because they may apply even if you're based outside the European Union, in the US, and offering respective services to the EU. So basically what we have found out in the EU, we may not be the best in developing things, in innovating. So the US is much, much stronger in that regard, but we're super strong in legislating. So with the GDPR, which is considered by EU legislators a huge success because it has been rolled out in a similar way to many countries. Many countries have adopted similar privacy laws as we know them in the EU. And the idea, I think, from the European legislator is to come up with a similar success story for the AI Act and to have other countries copy the respective requirements. Yeah, so much with respect to AI. I don't know, do you have any questions in that regard? Do you use or develop AI? Any thoughts that you want to share in that regard?
One quick question, Paul. So you talk about there can be issues when train AI models with copyrighted data, right?
Yes.
So it's very fundamental question, just for my understanding. Now, if we take humans, right? So we do learn from a lot of copyrighted materials, and we share
Yes.
that data, right? So that will be part of our learning, whatever things
Yes.
that we learn from copyrighted materials. But
Yeah.
we share that data with anyone, so there are no copyright issues there. I mean, not as it is, but we
Yeah.
share our learning, right? So why that is not applicable for AI models?
Yeah.
Like, why can't AI models learn from these copyright materials and then use that to make decisions?
Yeah, that is a very interesting question. So, and to be honest, the questions in that regard, they are not solved yet. So this is just a discussion that has been upcoming, but very so. And copyright laws are a bit different across the world. But for example, from a European perspective, copyright laws tend to have a very strong protection for the person owning the copyrights. And I think that is the case in many countries. And basically, they want to protect the copyright holder to a very, very large extent. And basically, if a software runs through the information for training purposes, this means that it is a kind of use of the copyrighted material. Yeah, different from a human reading a book. Yeah, it is actually software using the respective copyrighted material to develop something new. And that in itself is likely to be considered a new form of use of the copyrighted material. And so because computers do it, it has to be assessed differently than from what humans do with it. And reading a book would likely not be a copyright issue, but putting data on a website already is something that would be protected by copyright, or where copyright law would apply. And if a software actually takes this kind of data in order to include it into their training system and then come up with something else, that in itself will actually be a protected use case from a copyright perspective.
Sure. Yeah. Yeah.
Yes, I was going to say something very much along the same lines. I mean, I think this is going to be a very, very big area for a lot of lawyers, isn't it? When you've created something like you've created an idea, then you've got a thesis published on it, and you own the intellectual property, and then ChatGPT goes and reads that, and yes, puts it in different words, but effectively it's your intellectual property. Then yeah, they're going to be a lot of trouble around things like that. And I think it's going to keep the lawyers in business for a very long time.
Yeah. And I mean, this is like, and Don, the use case that you are mentioning is even a very obvious one. Let's say you have written like a book or a blog post on a website, and then an AI tool takes it and summarizes it for you. So basically, then it is very clear and very very strongly attributable to your specific copyright, and then it's basically taken and prepared in a different format. So I think here the copyright impact is very foreseeable, very obvious. But there may be other cases where it is even not that foreseeable, not that obvious, but still can pose copyright issues. So let's say the blog post is just scrawled, and the AI, the algorithm learns from it, but then the information is deleted again. So it has only been used for a short period of time in order to train the algorithm, but then there is no summary, no specific outcome of that IP, but it has only been introduced into the overall algorithm of the software. But even that, where it's much less obvious, can potentially pose copyright issues.
Mm.
Yeah.
Paul, go on. Sorry,
Yeah.
Prabhat. I had a question as well, but I can wait.
Go ahead, please. Yeah, go ahead, Dheeraj.
Okay, thanks. Yeah, Paul, I have a question about whatever you said is a bit abstract to me so far, because I wanted to converge it to more concrete use and what we can't do at all. Like in my organization, we are starting to use, for example, the co-pilots to generate code. Now, is it prohibitive or is it allowed? How do we know these things with the AI Act?
Yeah, so I think you have to differentiate between you as a user of AI and the developers of the AI. So many of the obligations actually fall with the developer of the AI. So like how they learn, what kind of training data, etc., will be with the developers. But for you, for the users, there are of course also requirements. So if we speak about the AI Act in future, that may for you include the obligation to check whether the AI software includes sufficient safeguards and security requirements. For example, that can be the case if there in Europe we have a CE mark on the products to ensure it has run through a conformity assessment and has been proven to be in compliance with the applicable requirements, those kind of things. But even right now, for example, and I don't know exactly how Microsoft rolls out Copilot, but you may need to conclude potentially a data processing agreement with Microsoft to ensure that the data that you input to the system, and often it will be used in the cloud, that it is only used according to your orders and that confidentiality remains. Yeah, probably that, again, I don't know how this will be rolled out. Maybe this is just part of 365 and subject to the same contractual requirements you have under 365, but potentially it's not, and different requirements may apply. And then maybe the AI may learn from it, and then you put data into it and confidentiality cannot be ensured. That can be an issue. So it's not something that you can say very abstractly with respect to all AI, but you have to look at each individual business model. What are the contractual terms? What are the liability risks involved? What kind of is it? Does the tool work with data that is really very precious to your business, or is it something that is a bit, where it doesn't really make a difference? And the risks may really vary in that regard. So I would assume that there will be a way to lawfully use Copilot in your near future, because Microsoft will probably have made up its mind about how to roll it out in compliance with applicable law. But still, very often those tools are produced by startup companies, and they move fast and break things. So compliance second. And very often you will have issues, and we have seen it with ChatGPT, with OpenAI in Italy. Basically, just a few weeks after it has been made public, the Italian data protection regulator issued a ban on ChatGPT, and it couldn't be used for a few weeks in Italy until OpenAI has amended the systems. And for example, now it has concluded the possibility when using it to opt out of the training of the data of your prompts. Basically, before it has learned from your prompts, and now you have the possibility to opt out of that regard in order to mitigate the most relevant data protection concerns. So there are certain things, and the ones that I mentioned, they are abstract. Yeah, they apply to everything, but which particular risk applies to the very one tool you want to use, and whether this risk really materializes will have to be checked in more detail. What we see companies doing, in order to wrap this up, maybe as a quick win, to have some kind of guidance on how to use those tools. Yeah, for example, one possibility may be to use just pre-approved tools that have been checked from a cybersecurity and a confidentiality standpoint to ensure that only this kind of data or these kind of tools are used. Or if you want to have it a bit more free flow, at least to inform users about the confidentiality risk involved, and tell them, look, just use it with dummy data. Don't upload actual confidential data. Maybe replace specific confidential information and then introduce it again afterwards, or those kind of things. So just to think about the risks that can be relevant to your business and try to mitigate those. Yeah, and then you have at least something in place to, well, you probably won't get rid of all the risks, but at least of the most relevant ones.
Yeah, thanks for the clear answer.
Yeah. So one thing that we're doing, because we're playing at the moment, but one thing we're doing is we're building our own model in-house rather than using one of the public models. So that's really because the data is sort of stored on our own servers and we're not sharing it out.
Yeah. So like from a confidentiality perspective, that certainly can mitigate those respective risks. Depending on your resources, etc. Of course, other risks may rise, yeah, like cybersecurity. Maybe if you do something on your own, you have more limited resources because you do it in-house than if you would rely on a big third-party provider that has run through various development cycles already and has reassessed that everything is in line with security requirements. So it doesn't remedy all the risks, but it may mitigate some risks in that regard. And actually, even with the big providers, there are possibilities sometimes to have the trained models run on premise, rather than in the cloud, or the possibility to have specific confidentiality or data processing agreements in place with those providers. So there are at least some kind of risk mitigating measures involved in that regard.
Okay,
available.
Cool.
Yeah, Paul, one quick question. So in GDPR, we talk about right to be forgotten, right? So when someone requests to delete their account, so we remove all the PII data, but still, we'll have the things that we learn from their behaviors with us, right?
Yeah.
So those won't get deleted.
Yes.
What's your take on that? Like, we would any provision in the AI Act to address that?
So there are discussions ongoing about that. I would say, also from a pragmatic perspective, what you have learned from the data, at least if you have lawfully obtained that data in the first place, and then just the right to be forgotten request has been made, what you have learned and the algorithm that has changed due to the data, I think you can keep it, and the right to be forgotten does not require you to go back to your algorithm and find out what was the learning and take that from the algorithm. I think that probably will also be will not be feasible in the end. So I think in most cases, unless this learning means that the algorithm can reproduce the specific personal data all the time, then you should be fine to keep on using the algorithm despite a right to be forgotten having been exercised.
Sure. Yeah. Thanks.
Yeah. Any further questions with respect to AI? If
Paul,
not,
Shamil, I in my organization, from the customer success department, what we are currently using is like we are pumping customers' questions into the AI, basically the ChatGPT, and getting an answer, but we are not posting it back to the customer in order to improve the efficiency. So in the way that you said, if we put that information into the ChatGPT, again, it can be a violation of the law, right? So in order to explain these things to the another people, like say, I am trying to explain it to my colleagues or my management. Is there any website or any other resource that I can get? These are the restrictions. These are these things we cannot do. Or is that only the law form link that you have posted that we can use for that one?
Yeah, so there is, I don't know whether there is some specific guidance out there on ChatGPT. As I mentioned, it will really depend on the specific tools. ChatGPT, I mean, if you use the ordinary ChatGPT version, to my knowledge, this is a B2C only according to the contract terms. Yeah, so unless you have a specific, and OpenAI obviously offers the product also on a B2B context, but unless you have a respective B2B agreement in place with ChatGPT, you probably already have contractual issues there in that regard. You may potentially have privacy issues and confidentiality issues because you don't have, if you just use the ordinary ChatGPT function, you just provide the data to ChatGPT and they can just use it, and they know it's you as a user that has introduced it, and they can then reuse and learn with the data. So one mitigation measure in that regard would be to sign up to the B2B versions that OpenAI offers. So like they can provide you with a respective API. If you have the B2B version, they will be willing to conclude confidentiality and data processing agreements with them, etc. If for some reason you cannot do that and you want to take the risks nonetheless, at least try to opt out of the fact or of the opt out of the training capability of ChatGPT, so that ChatGPT does not learn from the data you introduce. At least you limit the respective confidentiality risks there to some extent, while you probably don't get them to zero.
Cool. Thank you so much.
Okay, if we don't have questions in that regard anymore, I will say a few words about new upcoming or existing cybersecurity laws in the EU. So actually what is happening from a legislative perspective in the EU currently is really crazy. You basically go to bed, wake up, and 2 new laws have been passed. Not only in the cybersecurity space, not only in the AI space, but also data monetization, digital content, hate speech, product liability with respect to digital goods, etc. So very broad, a lot of new laws coming up, and very, very onerous requirements. And basically what almost all of those laws have in common is they have an extraterritorial application. So they don't only apply to European companies, but also to international companies if they do business with Europe. And they introduce high fines often in the scope as we have seen it from GDPR. So GDPR says like 20 million or up to 4% of annual turnover. AI Act, for example, in the current version stipulates up to 7% of worldwide turnover or 30 million euros, whatever is higher. So the legislator in Europe has seen, well, high fines and extraterritorial applicability. That is our way to success to roll out those laws, and those key factors are basically webbed into almost every new European digital law. What a new law that has already been passed and that will be implemented in Europe now until October 2024 is the NIS2 Directive. Yeah, and the NIS2, as the name says, it's like the successor of the NIS1 directive that has been rolled out in 2016. And what NIS1 did was to apply cybersecurity requirements to any kind of businesses that provide certain services that are important for society as a whole. For example, energy, certain like water supplies, etc. So it's something that we really rely on, and without it, society really gets serious issues. And the NIS1 directive already introduced very high cybersecurity requirements and notification requirements if something goes wrong, but they left it to the European member states to introduce it into their local laws, and they left them quite a lot of liberty with respect to which specific companies are targeted, what are the thresholds for the law to apply, with respect to enforcement, with respect to the fines. So basically, in the end, every country did it a bit differently, and the NIS directive didn't have the power that the legislator wanted it to have. So the EU came up with NIS2 or NIS 2.0, a new NIS directive, which shall now be rolled out until end of next year, and which broadens the scope of application significantly. So quite a few new sectors are in there. For example, to a much larger extent than so far, also IT providers will be regulated, in particular cloud providers, for example, offering services to the European Union, and the thresholds for the law to apply will be lowered. So from October onwards, if you are within the covered industry like energy, waste, water, space, certain IT provisions, cloud services, then the law will apply if you have 50 or more employees or an annual turnover of 10 million or more. So very low thresholds for the law to apply. And if the law applies, quite a lot of requirements kick in. You have to implement quite onerous risk management measures. So you have to do a risk analysis and assess the risk to the information security. You have to implement SOPs for security incidents. You have to implement backup management processes, crisis management processes, disaster recovery processes. You have to ensure that your supply chain management with respect to information security is compliant, computer hygiene, encryption requirements, HR security requirements, multi-factor authentication, lots of risk management measures. So very, very, very onerous requirements in order to keep on doing business with the European Union. There are strict requirements for management. So the board will basically have to approve and supervise the risk management measures that have been taken, and the board or like the CEO can be made responsible if they don't act accordingly. And the CEO is even obliged to take part in training in order to build up knowledge and capabilities with respect to information security. If something goes wrong, you must notify the regulator, and you have to generally send out a first notification to the regulator within 24 hours. So not even the 72 hours that GDPR requires you to notify, but it will be 24 hours. And then after 72 hours, you have to do a more substantive notification. And after 1 month, you have to give a super substantive and hopefully finalizing report on what has happened. So very, very broad obligations in that regard. If you're based outside the European Union, but offer your services to the EU, then similar as we have seen it already, for example, also under the AI Act, but also under GDPR, you have to appoint a representative in the European Union in order to deal with individuals in the EU and with the respective regulators. So very, very broad, very onerous obligations, and potential fines can be up to 10 million or 2% of total annual worldwide revenues. We have DORA, a new law that applies in the financial sector. And DORA goes even beyond the NIS2 Directive. DORA applies directly in all EU member states without the need to introduce any local laws. And basically, it's NIS2 on speed. So you have the more or less the same requirements that NIS2 implements, but because it is the financial sector and that is super regulated, the requirements are even higher. So you also have very strict governance, control, and risk management requirements to be implemented. You have to implement a control function within the company, so like some kind of internal person that checks that everything is done properly. You have to build up a strategy for the so-called digital operational resilience in order to cope with the respective requirements. Similar as with NIS2 management, so the CEO has to be is responsible, ultimately responsible for implementing all of that, and needs to be trained with respect to information security requirements. You have to use the most up-to-date IT systems and logging capabilities. You have to notify to the regulator if something goes wrong, of course, and potentially even the clients. Yeah, you have to do regular audits, very, very onerous technical audits, pen testing, etc. And this is something where it can also become interesting, for example, for service providers or cloud providers offering services to financial institutions. There are very, very, very strict requirements with respect to involving third-party IT providers. Yeah, there you have to do a very thorough third-party assessment, and you have to document everything that has been done. The contract needs to include very strict documentation and reporting requirements. You have to do a really basically an audit of the third party before actually concluding the agreements. And there are specific requirements that need to be in the contract, for example, with respect to confidentiality, data protection, and collaboration with EU regulators. So very, very broad requirements. And for certain IT providers offering services to financial institutions that are considered to be critical by the EU supervisory authorities. They can name a few. For them, the requirements apply not only by contract, but directly by law. And they even have to set up, if they are non-EU companies, they have to set up affiliates in the EU in order to be allowed to provide services to European financial institutions. So very, very broad, very onerous obligations. But of course, it doesn't stop there. Another one, and then I'll stop with respect to the new laws, the Cyber Resilience Act. So different from the NIS2 Directive and DORA, the Cyber Resilience Act has not been passed yet, but actually there was a breakthrough yesterday. So it's probably going to be passed in the next couple of weeks, maybe month, but probably next couple of weeks. And the Cyber Resilience Act introduces very, very strict requirements for so-called products with digital elements. So basically connected goods. The idea behind it is that if you have a fridge that connects to the internet for inexplicable reasons, I don't know why you would need that, but if you have it, then basically the idea is if it can be hacked, then this may have an impact on the specific users. Yeah, maybe not so much the fridge, but or even the fridge that buys crazy stuff for you then, or health devices that give wrong indications then, for example. But not only risk to the individual users, but also to overall society. If you use all those devices that are not patched regularly, you can build up a botnet, and then you have millions of evil fridges attacking, I don't know, a state. So basically, the EU legislator said we have to ramp up significantly the respective cybersecurity requirements of connected devices, meaning there are very, very specific and onerous requirements on how to design, develop, and produce those connected devices. You have to undertake cyber risks assessment and again, carry out conformity assessments, and only if you confirm that you're fully compliant with CRA, you may offer those respective products. Very, very strong transparency requirements. So you have to explain to your customers the risks involved, the risk assessment that you did, and how those risks can be avoided. There are update obligations. So basically you have to keep the connected devices updated for the life cycle, for the expected life cycle. And you have to notify authorities and potentially users in case of vulnerabilities. So again, very, very strict, very onerous requirements with respect to cybersecurity of those products with digital elements that are connected to the internet. Yeah, so much relating to respective cybersecurity requirements. Happy to take any questions in that regard.
Yeah, I've got a question on that one. So just as a consumer, I mean, quite often you buy things which come with 1 or 2 year warranty, and manufacturers sort of have a period of time, but some people have fridges that are like 20 years old.
Yeah.
But how long are the manufacturers going to be beholden on maintaining that?
Yeah. So actually there was a change yesterday which potentially may limit this period, but the initial idea was the life cycle of the product, but generally 5 years. Yeah, so like as a rule of thumb, it was like 5 years, but I will have to see what the final result will come up with it. So it may not be as clear and may depend on the specific product potentially what the life cycle is, but like the initial draft spoke of 5 years as a rule of thumb.
And will that also affect things like smartphones? Because there are quite a lot of smartphone manufacturers who make phones and never send any updates out.
Yeah, so I mean, like basically any kind of hardware connected with the internet will probably be covered in that regard.
Yeah. Okay. Cool.
Yeah. So this is one this is really this is probably this is the first law. So like the other laws that we have with respect to cybersecurity are like vertical, have a vertical approach, so like a sectorial approach. They regulate financial sector or health industry or I don't know, energy. Yeah, so like a specific industry that is regulated. The CIA is different. It's horizontal. It regulates you regardless of the industry, as long as you have a product with digital elements, so like a mostly connected device.
Paul,
Right.
Paul, question about open source software, because there are all these people like, okay, when I make my software, I consume so much open source software. If you ask me, I don't even know who makes it. What's the implication on this?
Yeah, so I like if I'm good question. So if I'm a manufacturer of a respective product that introduces open source software, I have to ensure that even the open source components are patched. So I can't rely on it. I can't just say, well, it's a third-party component, and I don't care. Well, it's not patched anymore, then not my problem. This is probably not a decision to be taken. But then you have to ensure on how to further develop the open source components if for some reason those are not kept on being developed by the community.
Yeah, but like today it's such an open world, this open source software. We don't even know who writes the code, because I don't know if that's now a GDPR regulation or, but it's going to be chaotic, right? Or
it is going to be very, very difficult, I think, for many producers, manufacturers to actually implement that, because I agree they may not even know the risks they're dealing with, because things are just webbed in. Third-party components are just webbed in, and there has never been a holistic approach. But this is probably that, at least to some extent, that probably needs to change if the law enters into force.
Yeah, thanks.
Yeah, any further questions? If not, I mean, we're almost at the hour. I can also enjoy the rest of the day 2 minutes earlier, but happy to answer any further questions, of course.
I think that's been a lot of food for thought there, and a lot to take away.
Great.
I said in the chat, we are currently introducing an AI right now in our apps, because I work in the marketing side. So marketing people always want to be where the latest buzzwords are, don't they? So
of course, yeah.
We are currently doing everything for AI in as fast as we can. So.
Yeah, I think you're in good company in that regard.
Yeah.
Yeah, one question here. Do you think these EU regulations will make it less attractive for startups who can't afford the compliance costs? I mean, to be honest, very often, as I mentioned, like they build things first and think compliance second. So I don't necessarily this will stop startups developing things. But of course, once they grow, once they become or once they receive a certain visibility in their area, compliance may become a bigger issue in future than it has been in the past.